Serious rules about U.S. immigration. What you need to know. U.S. immigration policy affects millions of people, travelers, workers, families, and people seeking protection. Today we cover 10 serious rules or policies that shape how the United States admits, detains, and removes non-citizens. Rule 1. Title 42 and post-Title 42 border processing. A major turning point was the end of Title 42 expulsions, a public health-based removal policy used during the COVID pandemic. Since Title 42 ended in May 2023, CBP and DHS have relied on standard immigration law and other operational tools to process arrivals. The change does not mean automatic admission. Many migrants are subject to expedited removal, parole, or other processing, and DHS can still turn people away under different authorities. The practical result? Larger reliance on asylum screening, expedited tools, parole programs, and case-by-case discretion at the border. Rule 2. Expedited removal and the credible fear screening. Expedited removal allows CBP to quickly remove someone encountered near the border or at a port of entry if they are inadmissible and have no valid immigration documentation. However, if someone says they fear return or request asylum, they must be given a credible fear screening by an asylum officer. If they pass that screening, their case is referred to immigration court for a full hearing. If they fail, they can generally be removed without a full hearing. This screening step is a critical legal gateway for asylum seekers. Rule 3. Asylum eligibility and common bars. Asylum is available to people who can show persecution or a well-founded fear on account of race, religion, nationality, political opinion, or membership in a particular social group. But there are important bars and deadlines, a one-year filing deadline after arrival, with narrow exceptions, ineligibility after certain criminal convictions, and potential bars for people who passed through another country and didn't seek protection there. Also, concepts like firm resettlement, if an asylum seeker was resettled in another country first, can bar asylum. Courts and regulations change, so each asylum case is fact-specific. Rule 4. Unlawful presence and re-entry bars. Staying in the U.S. without lawful status can trigger unlawful presence. More than 180 days of unlawful presence followed by a removal and then re-entry, or attempted re-entry, can generate a 3-year bar. More than 1 year can trigger a 10-year bar. Separate rules can create permanent bars if someone is unlawfully present for more than a year and then re-enters without authorization. These bars affect eligibility for returning to the U.S. legally, for example, through consular visas, and often require waivers that are difficult and discretionary. Rule 5. Family-based immigration and the Visa Bulletin. U.S. family immigration is split between immediate relatives, spouses, unmarried children under 21, parents of U.S. citizens who are exempt from numerical limits, and family preference categories, adult children, siblings and spouses, children of green card holders. There are numerical limits, per-country caps, and long backlogs for certain countries and categories. The Department of State's Visa Bulletin sets which priority dates are current. When retrogression occurs, applicants can face many years' wait. Also, note the Affidavit of Support, Form 1-864. Family sponsors must show financial ability to support the immigrant. Rule 6. Employment-based visas, H-1B lottery, and employer obligations. Employment-based immigration has its own caps and processes. The H-1B specialty occupation visa remains subject to an annual cap, $65,000 regular plus $20,000 advanced degree cap, and a registration lottery system. Employers must comply with labor rules, pay required wages, maintain public access files, and complete Form I-9 and, where required, E-Verify. Employers who knowingly hire unauthorized workers face fines, and serious violations can lead to criminal penalties and debarment from government contracts. The H-1B process and visa priority systems are technical and competitive. Rule 7. Public charge considerations. The public charge concept affects whether an immigrant seeking a green card is likely to become primarily dependent on government assistance. After legal and policy changes in recent years, the federal government has returned to a more traditional totality of circumstances test based on long-standing guidance rather than the expanded 2019 rule that counted many non-cash benefits. Receipt of certain benefits can still be a factor, but most health and emergency benefits for children and pregnancy are excluded. Public charge is complex and fact-specific. Getting accurate, up-to-date guidance is essential for applicants. Rule 8. Detention, bond, and immigration court backlogs. Non-citizens can be detained by ICE pending removal proceedings. Some categories, for example, certain criminal convictions or specific inadmissibility grounds, can result in mandatory detention. Immigration court proceedings are handled by EOIR and do not provide government-appointed counsel for non-citizens. Representation is by private lawyers or non-profit legal aid. The immigration court system has a substantial docket and long backlogs, meaning many cases take years to resolve, and detention, bond hearings, and relief applications have serious consequences. Rule 9. Criminal convictions and deportability. Certain criminal convictions make non-citizens removable. Distinctions like aggravated felony, crime involving moral turpitude, and controlled substance offenses carry different immigration outcomes. Some convictions bar asylum, cancellation of removal, and other relief, and can also trigger mandatory detention or enhance penalties. Criminal defense lawyers do not always understand immigration consequences, so collateral consequences counsel is critical for non-citizens facing criminal charges. Rule 10. Humanitarian tools, TPS, parole, and humanitarian relief. The U.S. uses several humanitarian tools. Temporary protected status, TPS, for nationals of countries experiencing conflict or disasters, humanitarian parole for limited emergency entry, deferred action, discretionary relief in certain cases, and special programs for refugees and certain population groups. TPS designations and parole programs are time-limited and program-specific. They do not automatically lead to permanent residency, though some individuals may later qualify for other pathways. Because these tools are discretionary, program rules, eligibility windows, and processing priorities matter a lot.